Let's just finish off that tshuva where we were yesterday. So we were talking about, so according to Rab Sharaga, it seems like he is lenient and does allow you to go after the insurance company in court. Now, he didn't really specify that the defendant in the court case has to be the insurance company. Invariably, at least in North America, usually the defendant is the individual person who's the insured, not the insurance company. But he didn't make that distinction. And so I'm hoping that his words will extend to a situation where you're suing the individual knowing that you're really, the insurance company of that individual is going to be the party that is going to be legally fighting the case. It's not so simple, give you an example. Let's say you slip and fall outside of someone's house, right? So the person has homeowner's insurance. So does that mean that I now have license to go ahead and take the individual to secular court because because I know that it'll be covered by his insurance company? What about the fact that he has a deductible, right? And that all, does that play a role in consideration as well? He hasn't really addressed any of these things in this tshuva, and so I'm a little bit sort of not completely satisfied with the full extent of this, and I may want to try to research this a little bit more thoroughly. Yeah, and actually, maybe I'll give a sugya share about this topic. So we'll see. But it's actually quite an interesting shaila. So the last thing that we saw, he says is that even though you're not allowed to normally sue another Jew in secular court, but mikol makom me'achar sheyadua shahachevrat bituach lo tavo lodin b'din Torah. But if it's already clear that the insurance company that is representing this fellow will not come to a din Torah, ve'in shum efsharut acheret litvoa otam b'din Torah, and there's simply no other way to obtain compensation using Beis Din, yachol l'tavim be'erkot, you're allowed to even completely avoid Beis Din entirely. Like you don't even have to get permission from Beis Din, based on what we saw yesterday, and you can just take him to secular court. And the same thing is true if you're going to be suing your physician who's a frum guy. But again, like I said, there are many situations like a homeowner's insurance kind of case, or a fender bender, is there any requirement for, but I think in a fender bender kind of situation where the fellow has already reported it to the insurance company, there are many situations in automobile accidents where it's no fault insurance. I don't know whether that's true in Israel or not, but let's say the two people get into a car accident, and normally what we say is, get the police report. Each of you report it to your respective insurance companies. If you can't come to sometimes the two parties basically say, listen, I know, one says to the other, I know it was my fault. I'd rather avoid having my premiums go up. Get a couple of estimates and I'll pay you, right? So there's no din Torah over there. So you have nothing to worry about. There's no question of where the litigation should take place. But let's say they can't agree. Let's say the guy says, you ran the red light, and he says, no, I didn't. Right? So then you have to get the police report. You have to get the insurance companies involved. I don't see the role of a Beis Din in that situation either, because it's usually no fault insurance. The times when it would be relevant is that, let's say, a person gets injured and he wants to get damages from the offending party. So that may be where there's going to be litigation. But since by that time, the insurance company has already completely involved in the situation. So there's also really no room for a beis din to get involved. I think what's more, what would be more of a likely situation is if, a guy has a slip and fall situation, let's say homeowners insurance kind of thing, which actually happened to my mother not too long ago. A neighbor of hers fell on the sidewalk outside of her home and injured herself. And her insurance company advised her, sue the homeowner. My mother was sued by the homeowner. And you would think so, but not in the state of California. Right? It's one of the other privileges that you have for living in the state of California, is that you have to maintain your sidewalk even though it doesn't belong to you. Is that true in Ontario also? For shoveling, yeah.
But if there's something faulty in the sidewalk, if it's blocked or something like that.
No, city ain't California. They're horrendous. Yeah. Correct. Yeah, it's really interesting because I walk differently when I'm in California. When you're in California, number one, you have to keep your eyes on the sidewalk. And also I noticed, like, even subconsciously, I lift my feet higher when I'm walking on the sidewalks in LA, because they're always uneven. There's always, there's never 2 blocks of concrete that are ever aligned properly. Yeah. It's also because of earthquakes, because the shifts that take place. Yeah.
Initially, we're going to cover, in which case they get on to the fan, they pay the lawyers, and they go all the way with it. Or they say, look at this, the adjuster or whatever, and there's no coverage, right? And one of the reasons why there might not be coverage, for example, is the peril or the event's not covered with their interpretation of it. Or you admit liability to the other side, you get out of the car, I'm sorry, it's my fault. They may say, point of coverage, right? That's another defense they use. Or they may say, we're on the fence, we'll wait till depositions or discovery, and you have to sign a non-waiver, which means we're in it for now, but we're not committing to pay out anything on your coverage until later. And many times you get a letter saying non-waiver, whatever, and at the end they say, no, your fault or whatever, not fault or whatever, and they don't pay. So you don't really know at the outset whether the insurance company is going to take up the burden of payment.
That's also interesting.
Yeah.
So,
well, that's true. Then maybe you do have to go to base.
I'll give you an example. I had to cancel a flight. One of my sons required medical attention. Okay, that's legit. Except when the issue that required attention predated the flight. So, okay, let's say you have a hernia, and all of a sudden your hernia strangulates, and you have to cancel your flight. But you had the hernia, happened to strangulate, not that problem.
Remember years ago we had that big flood. A lot of people put in their insurance company, all the ice cream, all this stuff like that. They didn't have the coverage. They didn't pay. They didn't have an endorsement for that peril. Or earthquakes, or whatever. You've got to look at your policy, and everything that happens that causes you to make your claim has to be covered with a reasonable interpretation. If it's beyond the pale, there's no coverage, right? You didn't pay for that insurance.
so my homeowner's insurance doesn't cover flooding?
I don't know.
Depends whether you have an endorsement.
You have to look. You have to look.
And there's different kinds of flooding as well.
Yeah.
Like the sewer backup, and then it's like,
It might say from water excluding sewer backup. It might say water except for, like an act of God, like whatever, is it an act of God?
even though we know everything is an act of thought, but that's besides.
Okay.
The insurance companies are notorious. You pay your premiums at the end of the day. What? Yeah.
Okay. All right. So this is not
It's
as,
not meant to cause you grief.
yeah, I know. Well, no, it's always good to know these things. Look, at the end of the day, what we're seeing from here is that it's not as clear cut, perhaps, as he's presenting it, because I'm suing the individual Jew. I'm not suing the insurance company. And Rav Sharaga's conclusion is that since your insurance company is invariably going to be involved, and the only way to get them involved, if the only way to get them involved is to go to secular court, then you have a heter to go to secular court right away. But it may not always be that simple, is what Marv is suggesting. Okay, so I have to research this a little bit further. Final paragraph of this tshuva is he says, "V'tzarich harofe lahayid edus emes k'dei sheyakabel hachola es hapitzuyim." Now, the fact is, the physician has a halachic duty to testify truthfully and not cover his rear end, if you know what I mean, right? And that unfortunately happens, is that sometimes a doctor will make a genuine mistake, right? And out of a desire to protect his reputation, he won't own up to it. Or any care provider or any professional, right? Or a guy who is in a car accident. He knows he was at fault, right? But he doesn't want to admit to it because then he knows maybe his insurance company won't cover him. Okay, afal pisha habituach notein pitzuyim gevohim yoter mima shehaya magia lo al pi din Torah. And that's true even if the insurance company will be paying out to the plaintiff more than what the plaintiff would be entitled in a beis din for those same damages. Kevan shehabituach hitchayev lekach u'chemo shekatavnu le'el. Since that was a fiduciary obligation of the insurance company, once the insured, the physician, bought the insurance policy, the insurance company basically committed to pay damages according to what secular law would impose. And therefore, the doctor is not doing anything untoward by telling the truth. To the contrary, he is allowing the partner, the business arrangement that he has with the insurance company to kick in properly, and they will pay out what they agreed to pay out. And therefore, the bottom line is any kind of financial obligations that can only be extracted in secular court, such as damages from an insurance company, mitzvah al hayodea edut lachavero, lahayid sham bichdei lahatzil mamon chavero. It is also a mitzvah for an observant Jew to go ahead and testify in secular court. So let's say, you are a witness to the car accident, and your friend says, would you be willing to come and testify for me in court? And you say, well, the guy who hit you, he's from a yid. How can I go and testify against it from a yid? I know you're not allowed to maser someone in secular court, right? So what do you tell the guy? You're an idiot. What are you talking about, maser? This is getting money from his insurance company to pay the damages that the plaintiff is entitled to receive. There's no masira here. But if you would have gone to beis din, maybe they wouldn't. Doesn't matter. Fact of the matter is, there's a social contract, and anyone who's driving on the road has insurance. And since the only way for that insurance to kick in is through Hilchos, so Rav Sharaga says that's what you have to do. And therefore, if you're a frum yid and you can help someone get the insurance money, you're obligated to do that as well. And therefore, you're fulfilling the mitzvah of Hashavas Aveda, doing the proper chesed, that you're obligated to save a person's financial status to prevent him from incurring financial loss.
But isn't it the other way as well? If your testimony would hurt your personal thing, the other side says you have to testify against your good friend because that's the truth. You still have to go to court.
Yeah, of course you do, because you're
that's
helping.
a little bit more difficult then, right?
What do you mean it's more difficult? I mean, it's a question of halachic obligation.
Logically, I understand, but I'm just saying that it's easier to say, oh, well, yes, I'm going to go to court to help my friend recover from the insurer, but you're actually going to court to prevent his recovery from the.
Right.
but you have
Well,
to
let's
pay
say,
him.
okay, so your point is very well taken, Paul. Let's say I'm a witness to a car accident where a frum person rear ends a non-Jew. And the non-Jew sees that I'm a witness,
Yeah.
and he says, I know you from the neighborhood. Can I call you? Will you come and testify in court on my behalf? It could be that you don't have the same obligation of Hashavas Aveda because there's no mitzvah of Hashavas Aveda to a non-Jew. But there may be other halachic requirements of don't make a chilul Hashem. Like when we learned the laws of Hashavas Aveda,
Yes.
we learned that you are supposed to return lost items even to non-Jews when
And
there,
if it's
when
a
there would be a
secular-
chilul Hashem.
Ignorant, not offending you.
Uh,
Then you
well,
have Jewish responsibility.
You have Jewish responsibilities also. We learned that as well, that just because someone is not shomer Torah and mitzvot, he still has the status of a tinok shenishba, of a child who's unknowing, and therefore you have financial obligations just like you would have to any from Jew. So yes, so at the end of the day, it would seem that in all situations, you have to do the right thing and help someone retrieve their loss. Yeah. Got to tell the truth.
Criminal, and then you're the one whose conscience is, I can't take this, and it rolls through Jews, and I think that's where things get a little murky. When you're aware of something that is criminal, but it involves from Jews, now what?
Yeah. So I look, I can tell you that there's a variety of different opinions on the laws of Masira. Rav Hershel Schachter feels that there is absolutely no prohibition of Masira when someone is clearly in violation of the law of Dina de Malchusa. And you have an opportunity to avoid this crime being, running rampant throughout the community. You have an obligation to do something about it.
With the law is fair.
Well,
And
just. Let's say there's a white collar crime, which is usually what is the case, right? There's a tax evasion. There's let's say a false charity that's set up in order to help people make money, or some other kind of illegal kind of activity. Whether or not you have an obligation to call your local RCMP and initiate action, it could be that you don't have an obligation, right? I don't know what the Good Samaritan laws say about when you are aware that white collar crime is being committed. Do you have an obligation? Yeah. If you don't have an obligation to do so by secular law, then you probably shouldn't initiate like that phone call. But if you're called to testify, then you have to tell the truth.
Also doesn't mean that your testimony will be accepted and make you cross-examined. It might not be believed. It might be. I don't know what the jury or schedule or how it will be assessed.
Here's the problem, what I think one of us somebody was doing something that wasn't true.
Well, exactly what's happening was during the pandemic there was a number of people who signed up for the curb program to get the money because the government was just giving out the money. They couldn't check anything on everybody. I know people who actually signed up and did not qualify for that. Then afterwards, the government was just going to figure it out and left the people. But people who do not qualify, so I do call or
No. There's no, so like Marvin says, there's no requirement under the law to report your neighbor for taking a government grant that they weren't entitled to. You might have an obligation of tochacha There's a mitzvah of hocheach tochiach. There's a mitzvah of rebuking your fellow man, your fellow Jew, and saying, look, what you're doing is not right. That there may be, but there's no obligation, and it could even be that there might be a prohibition to go ahead and initiate action by reporting someone to the government. First of all, you could say, it's not my business. It's not my business to get my fellow Jew in trouble with the authorities. But I mean, certainly if I know a guy is doing it, I would tell him, because let's say a guy comes over to you and says, come on, Ron, the money, government's just giving out the money. Why don't you apply? I did. And then you say to him, but you don't qualify. He says, yeah, but they're never going to know that. So you should say to him, I'm sorry, but as an Orthodox Jew, that's not right. You should know better than that. You shouldn't be stealing from the government. Everyone's doing it. They're just giving away money. Right? I'm sorry, that's wrong. We should be held to a higher standard. Okay, so that would be the proper thing to say to somebody. It's probably not okay just to shrug your shoulders and not say anything to the guy. But that would be that's from a totally different mitzvah standpoint. That's from the mitzvah of tochacha, of rebuking someone when you know they're doing something wrong. Okay. Now, just to give closure to this last statement, he says, as far as testifying truthfully in court, he says, Hasvara bazahi, the harei hachevrat bituach kibla al atzma l'shalem l'nechbal kifi ma shahayu mechayivim otam be'erkaot. He says the argument is that the insurance company really accepted upon itself to pay whatever the court would tell it to pay. And it's even like from a Torah standpoint, like from based on the laws of the Torah, the insurance company indebts itself once a person, a policyholder, pays them a premium. And therefore, it's perfectly permissible for someone to be compensated an amount that far exceeds what the normal halach in a Beis Din would award them. And therefore, like there's a tshuva that says, he says, the imchasmu al shtar kedine erkos, that if two litigants go to Beis Din and they say that we would like to be, we agreed either contractually or when we committed ourselves to binding arbitration at the Beis Din, that we will be bound by punitive damages as we would be entitled to in a court in Ontario. Then both sides, then it's not ruling improperly. In other words, even though we learned before that the Shulchan Aruch says that a Beis Din should not rule according to secular law, because that in itself is a chilul Hashem, that you're ruling according to secular law instead of according to Torah law. But there are exceptions to that rule. This is a classic example. Let's say two people say we want to go to Beis Din, but the plaintiff says, but I don't want to forfeit what I would be entitled to if I took you to an Ontario court, because the Dina de Malchusa here is that in this particular instance, I'm entitled to punitive damages. And maybe the Beis Din wouldn't recognize that because that's not found in the Gemara, this type of punitive damage for this kind of industry, for this kind of situation. So it is permissible for two people to say, based on the social contract of where we live, I as a physician, let's say, or I as a patient have certain rights in the province of Ontario. I don't want to forfeit those rights by going to Beis Din. The Beis Din will say, you're right, we will accept that, provided that both the plaintiff and the defendant sign in their shtar berurin, in their arbitration agreement, that they will be governed by Ontario law in that kind of situation. Okay. All right. Valpi yesod zeh, and based on that principle, muter lahayid letovas hanechbal afal pi sheyotziu maman al pi ed echad, and therefore you can even testify knowing that there are not two witnesses, because normally the only way that a Beis Din will accept, to to pay out, to force someone to pay is if you need two kosher witnesses, right? That the person was injured or that or whatever the situation is. In secular court, you don't need two witnesses. All you need is one witness. Kevin shem kiblo alatzman ladunkach. But since this was the social sort of convention that the insurance company agreed to when it signed up the policyholder, they like basically, if a person agrees at the outset to obligate themselves even on the testimony of one witness, they can do whatever they want. The Shulchan Aruch itself says, Misha kibel alav karovo pasul, ben lioto dayan, ben lioto eid alav, that if normally a person can say, I want to be, according to Torah law, that person is not kosher to be a witness to testify against me because he's a relative, or that person is not qualified to be a dayan because he's a relative, okay? But if the defendant says, I accept that person as a witness against me, I'm fine with that. He can testify on your behalf, even though he's your cousin, and even though normally we would say he's not kosher, but I believe him. I think that he is a trustworthy individual and he's going to be objective. Afilu kibel echad mehapsulim ba'avera kishnei edim kesherim lahayid alav. Even when one of the people who's not kosher to testify has already accepted upon himself to testify improperly. Okay, gimel based in mumchim ladunlo, or let's say to be one of the dayanim. Im kanu miyado al zeh enu yachol lachzor bo ad kam l'shana. But if he made a kinyan and committed himself to it, you cannot retract. So let's say I know that, and that was one of the reasons when we had a din Torah, I didn't want to go to the established based in the city here in our community, because I knew that the defendant in the case that we were suing somebody had a special, financial relationship with one or more of the dayanim, because he was a person of influence, right? And I said, we don't want to go to the established beis din because we feel that that the one or more of the dayanim is going to be biased, because this person is a true community person. He supports a number of different institutions, including the institutions that this rabbi is directly getting salaries from. And so we don't want that. It's a conflict of interest, and we don't want that to happen. But let's say a person knows that, it's fully disclosed to him, and he says, I accept that, judge, because I still believe I'll get a fair shake, right? So that's perfectly legal as long as you sign off on it. And the same principle is true with an insurance company. When the insurance company gave, let's say, a policyholder a policy because he paid the premium, their contract, their commitment to him was that even though, let's say, a beis din would not recognize the evidence that would compel us to pay, if the secular court finds us to be liable, we will pay regardless of what halacha would require us to pay. So, like, even if the insurance company is an Orthodox Jewish insurance company, it's owned by frum Jews, they basically accept upon themselves to be bound by secular law and whatever the secular courts will tell them. And therefore, that's the type of contract that exists between the insurance company and the insured. And based on that, even one witness can testify to compel the insurance company to pay. And therefore, it's a mitzvah on anyone who knows a testimony to help this person extract money from the insurance company to go and testify. So that is basically the psak. There's still some areas here where I think there's still some gray, which we should probably look into. I'm just going to sort of mentally put a circle around this tshuva, because there's really more meat here that needs to be investigated. What about deductibles and so forth and so on? So, okay. So I think we'll hold it here for today. We'll start a new tshuva tomorrow.